Good morning. The Judiciary Committee will come to order. Without objection, the chair is authorized to declare a recess at any time. Pursuant to notice, I now call up H.R. 5468 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 5468, to amend Chapter 7 of Title 5 United States Code to provide for certain limitations on judicial review of agency actions and for other purposes.
Without objection, the bill is considered as read and open for amendment at any time, and I'll begin by recognizing myself for an opening statement. America's voters sent the 115th Congress to Washington to help turn around this nation's struggling economy. In large part, the voters wanted us to do that by making sure government finally got out of the way of recovery. The Judiciary Committee has been doing everything it can to fulfill that mandate. The Trump administration has as well, and the gains Congress and the administration have made to date in cutting red tape have translated directly into record lows in unemployment, higher wages, and a booming stock market, surging levels of consumer confidence and spending. The specific issue before us today, reform of America's outdated, slow-moving permitting system, forms a big part of that picture. And the legislation before us today, the Permitting Litigation Efficiency Act of 2018, would represent a very big step forward in achieving a federal permitting system that is both fair and efficient. Truth be told, the committee made a big down payment on permit streamlining reform during the 114th Congress, helping in the enactment of Title 41 of the Fixing America's Surface Transportation Act, FAST 41, contained the biggest permit streamlining reforms in recent years. Its implementation is in full swing now, and it has already begun to clear the logjams that have stood in the way of permitting decisions for many of the nation's largest proposed construction projects. The Trump administration has been working hard to implement FAST 41 as effectively as it can. The same week we held a legislative hearing on today's bill, the administration's leading permitting agencies signed a memorandum of understanding committing to even more steps to reach quicker permitting decisions, including by agreeing to meet a 2-year target for the issuance of decisions for large infrastructure projects. These reforms mean faster decisions and faster delivery of jobs and investment for projects that win a permitting green light. But there remains much work to be done. Good as it is, FAST 41 is scheduled by its own terms to sunset in 2022, unless Congress extends it. Further, FAST 41 applied only to specific categories of the largest construction projects, those involving $200 million or more in investment. Many other projects still need permit streamlining reform. And to help ensure FAST 41 is not allowed to expire, Congress should legislate permit streamlining reform applicable to all construction projects before FAST 41's sunset arrives. The Permitting Litigation Efficiency Act of 2018, of which I am a proud co-sponsor, delivers precisely that reform. It establishes a strong incentive for permitting agencies to wrap up their permitting decisions for yay or for nay within 2 years. It also, like FAST 41, sets a prompt statute of limitations for lawsuits challenging those decisions, requires those suits to be based on matters actually presented to the permitting agencies during the administrative process, and assures that judges considering preliminary injunction requests in those cases will take into better account the potential economic and environmental harms of delaying project construction by injunctions. These are balanced, bipartisan, and sorely needed reforms, and I urge my colleagues to support this important piece of legislation. It's now my pleasure to recognize the ranking member of the committee, the gentleman from New York, Mr. Nadler, for his opening statement.
Thank you, Mr. Chairman. Before I begin my statement, I must make an urgent request. On Monday, President Trump took to Twitter to attack Attorney General Sessions. He stated, quote, "Two long-running Obama-era investigations of two very popular Republican congressmen were brought to a well-publicized charge just ahead of the midterms by the Jeff Sessions Justice Department." He continued, "Two easy wins now in doubt because there's not enough time. Good job, Jeff," close quote. Let us set aside the fact that these two prosecutions are not Obama-era investigations. This is not the first time that the President has attacked his own Department of Justice. He has publicly humiliated Attorney General Sessions before. He has accused federal investigators of political bias when, by all appearances, they were simply following the facts and the law. And he has already commented publicly on an ongoing criminal investigation without regard to how his comments may influence the outcome of the case or the fair administration of justice. But this is the first instance, as far as I know, where the President has directly called for the Justice Department to initiate or refrain from prosecutions for deliberately partisan political reasons. In a democratic society, we cannot tolerate political decisions with respect to prosecutions. This committee must address the President's inappropriate behavior now. Our response to the President's reckless accusations should take precedence over almost everything else on the calendar, and it certainly should take precedence over the Permitting Litigation Efficiency Act of 2018. I understand that these two criminal cases involve our colleagues, and that we should exercise discretion in discussing President Trump's reaction to these particular charges. Nevertheless, we must have this discussion. Accordingly, I now move that the committee immediately proceed to executive session pursuant to House Rule 11 so that we can discuss this matter in private and develop an appropriate response to the President's dangerous comments.
Would the gentleman yield before the motion is heard?
The motion is not debatable, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Smith? Mr. Smith votes no. Mr. Shabbat? Mr. Shabbat votes no. Mr. Issa? Mr. Issa votes no. Mr. King? Mr. King votes no. Mr. Gomert? Mr. Jordan? Mr. Jordan votes no. Mr. Poe? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Labrador? Mr. Labrador votes no. Mr. Collins? Mr. DeSantis? Mr. Buck? Mr. Ratcliffe? Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson votes no. Mr. Biggs? Mr. Biggs votes no. Mr. Rutherford? Mr. Rutherford votes no. Ms. Handel? Ms. Handel votes no. Mr. Rothfuss? Mr. Nadler? Mr. Nadler votes yes. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Ms. Bass votes aye. Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Schneider? Mr. Schneider votes aye. Ms. Demings?
Has every member voted who wishes to vote?
Mr. Chairman, may I ask, I'm not sure how I'm recorded.
Gentleman is recorded as a no, as an aye.
Oh, see, that's their confusion. Was it no or aye? I think I'm supposed to be an aye.
Aye.
Thank you.
Clerk will report. Oh, for the gentleman from Colorado.
Mr. Buck votes no.
How am I recorded?
Aye.
Thank you.
The clerk will report.
Mr. Chairman, 8 members voted aye, 13 members voted no.
And the motion is not agreed to.
Mr. Chairman,
Purpose of the gentleman from New York, seek recognition.
to make the opening statement on the bill.
You can proceed.
Thank you. Mr. Chairman, today we are considering yet another deregulatory bill destined to go nowhere. We should at least consider the implications of the so-called Community Safety and Security Act, a far-reaching and complicated measure scheduled for the floor this week for which we never held a hearing, let alone a markup. I would hope the committee would redirect its priorities to consider these matters in the time we have left in this Congress. Instead, today we are considering H.R. 5468, the so-called Permitting Litigation Efficiency Act, a blatant effort to undermine the federal environmental review process in the guise of administrative efficiency. This bill would put a thumb on the scale in favor of approving construction projects and real estate developments that may have a negative impact on the environment. It does so by restricting judicial review and by limiting public participation with respect to the federal permitting process for such projects. This legislation is yet one more attempt by the majority to favor powerful developers over those who wish to see proper environmental protections in place before major construction projects begin. The bill includes several draconian provisions. First, it amends the Administrative Procedure Act to mandate a federal court to presume unreasonable delay if a federal agency has not taken final action on a required permit within specified narrow timeframes. Second, it drastically reduces the general 6-year statute of limitations for actions against the government to just 180 days or less, with certain exceptions, and it seeks to skew the court's analysis of agency permitting decisions in favor of the project sponsor. With respect to the imposition of temporary restraining orders and preliminary injunctions against the permitting decision, the bill requires the court to consider, among other things, such relief's impact on undefined terms like, quote, economic interests, and, quote, the employment of United States workers, unquote, whatever those mean. Given the bill's failure to define these terms, H.R. 5468 will spawn needless litigation and will force the courts to use their own interpretations of their meaning, neither of which will clarify nor expedite the judicial review process. Another egregious provision would authorize a court to condition the issuance of a temporary injunction on the payment of a bond of up to $5 million. This provision is obviously intended to discourage challenges to agency permitting determinations, particularly by individuals with limited means, by underprivileged communities, and nonprofit entities who are unlikely to be able to afford such an exorbitant payment. It is clear that the cumulative goal of these requirements is to curtail public engagement and judicial review in favor of expediting approval of proposed construction projects that may have detrimental environmental impacts. In addition, this bill is a thinly veiled attempt to amend the National Environmental Protection Act, a law, I should point out, that is not within this committee's jurisdiction. NEPA, which was signed into law by President Nixon in 1970, requires federal agencies to consider the environmental impact of certain projects and to ensure the involvement of the public and other appropriate agencies. For the most part, NEPA has worked well, and the principal sources of delays in the federal permitting approval process are not generally attributable to that act. Such delays usually result from such disparate sources as insufficient project funding, concerns raised by state, local, or tribal communities, project complexity, and other factors unrelated to judicial review of the project's environmental impacts. But rather than having the committee with subject matter jurisdiction of NEPA and the expertise to consider any necessary amendments to that act, the proponents of this bill want to do an end run, and they seek to invoke our committee's jurisdiction under the guise of amending the Administrative Procedure Act, a law that applies to administrative law in general. This bill seeks to stack the administrative process in favor of finding unreasonable delays whenever agencies engage in otherwise proper environmental review. The end result will be to force approval of construction projects before the necessary reviews are complete. And instead of relying on the flexible standard for injunctive relief contained in the APA, the bill would carve out a judicial review exception solely for construction projects and other real property developments in order to achieve its sponsor's ideological goals. As if the current administration were not already doing enough to undermine a vast array of environmental and safety regulatory protections, the majority now seeks to enshrine its anti-environmental agenda into law. Not surprisingly, this bill is strongly opposed by a broad spectrum of environmental and public interest groups, by administrative law experts and others. I strongly oppose this bill, and I encourage my colleagues to oppose it as well. I yield back the balance of my time. Thank you.
Chair thanks, gentlemen, and now recognizes the chairman of the Subcommittee on Regulatory Reform, Commercial and Antitrust Law, the gentleman from Pennsylvania, Mr. Marino, who is also the chief sponsor of this legislation, for his opening statement.
Thank you, Mr. Chairman. Following the recession, the media reported that it took 6 years for the nation to fully recover the jobs lost. For years, millions of Americans faced economic hardship, searching for work to provide for their families. With an able workforce and employers eager to create jobs, our government's slow permitting of construction projects had stifled economic growth. The 2009 stimulus bill failed in its capacity to deliver timely recovery due to the federal government's red tape, limited permitting, litigation system, and, as President Obama remarked, too many projects not being shovel-ready. A 2011 study of proposed projects in the energy sector identified 351 shovel-ready projects that, if approved, could have generated $1.1 trillion in economic activity and create 1.9 million jobs annually. The reality, however, is our permitting system was inefficient, giving businesses overwhelming delays in administrative review rather than opportunity to grow. In 2015, Congress responded with passing permit streamlining reform in Title 41 of the Fixing America's Surface Transportation Act, commonly referred to as FAST 41. Though a step in the right direction, FAST 41 was subjected to a 7-year sunset. If Congress does not extend FAST 41, all of its reforms will be lost. It is clear that more needs to be done. My bipartisan bill, H.R. 5468, the Permitting Litigation Efficiency Act, is a straightforward, fair response to meet that need. In an effort to prevent unreasonably delayed permitting, my bill sets a 2-year default rule consistent with action taken by the Trump administration to implement FAST 41 for an agency granting or denying a permit application. If action is not completed within this 2-year window, a court can ensure the responsible agency resolves the delay. FAST 41 brought reforms that require potential challengers to an agency's decision to file suit without delay and limit the scope of the suit to those arguments the agency considered during the administrative process. The legislation includes and extends these reforms. This will eliminate bad faith litigants who remain silent during permit review and wait for up to 6 years as allowed by current law to bring a suit. These job-killing anti-growth litigants often hide arguments from the agency for as long as possible in an effort to inflict the maximum amount of damage on project developments. Building upon FAST 41 reforms, the Permitting Litigation Efficiency Act ensures recent advances in permitting reform and not lost. This litigation and legislation highlights the need for reform to prevent the kinds of infrastructure crises that communities throughout the country could face without further legislation. I look forward to this markup and encourage my colleagues to join in moving this legislation out of committee. And I yield back.
Thank you, Mr. Marino. The chair now recognizes the ranking member of the Subcommittee on Regulatory Reform, Commercial and Antitrust Law, the gentleman from Rhode Island, Mr. Cicilline, for his opening statement.
Thank you, Mr. Chairman. For nearly 5 decades, the National Environmental Policy Act, NEPA, has saved time and American taxpayers' money while also ensuring that major federal actions that have a significant impact on the environment are safe and do not harm local communities. In enacting NEPA, Congress recognized that hardworking Americans deserve to have a say in how their taxpayer dollars are being used on major projects where they live. So whether the project is a new power plant or highway, this democratic framework ensures that concerned citizens, local businesses, and state and local governments have both a voice and an opportunity to be heard on the impact of federal decision-making on their community. But under the guise of streamlining the process, H.R. 5468, the Permitting Litigation Efficiency Act of 2018, establishes a corporate carve-out from NEPA, rigging the permitting process in favor of potentially dangerous construction projects and real estate development and against local communities. Simply put, this proposal would create a special rule for environmental permitting projects under the Administrative Procedure Act, which Congress designed to ensure transparency, fairness, public participation, and access to justice in the regulatory system, while placing a heavy thumb on the scales of justice in favor of regulated corporations. It does so by shortening the period for judicial review of these projects from 6 years to 6 months, with limited exceptions. The bill also chills public engagement in permitting decisions by authorizing courts to impose as much as a $5 million bond before a person can prevent construction on a potentially dangerous project through a preliminary injunction or temporary restraining order. This bonding requirement would apply to any party seeking a stay, including local governments, small businesses, concerned citizens, and nonprofit organizations, regardless of the merits of the case. Even worse, the bill would require courts to give this bond to defendants, regulated corporations, unless the court determines that the action was substantially justified, a standard that does not appear in current law and is not defined by the bill. The bill also unwisely disregards long-standing equitable factors that courts use to determine whether to grant injunctive relief. Instead, the bill requires courts to conduct a lengthy cost-benefit analysis of the economic effects of providing relief, a complex and detailed analysis that courts are ill-equipped to conduct. Finally, it's important to note that this bill does nothing to address the underlying cause of delays in federal permitting. I'm a strong advocate of making a comprehensive investment in our infrastructure, once the envy of the world, to create good jobs and expand economic opportunity by rebuilding our crumbling infrastructure. But making this economic investment requires a serious plan and federal resources, not a false trade-off between infrastructure and safety, public input, or the environment. There's ample nonpartisan evidence that delays in federally funded projects are due to inadequate funding, insufficient agency resources, and project complexity, not environmental protections and safety guardrails. In 2002, the Nonpartisan Congressional Research Service reported that transportation project approval delays are not caused by NEPA. They are caused by, and I quote, project funding levels, local opposition to a project complexity, or late changes in project scope, end quote, among other factors unrelated to NEPA. Dina Baer, who oversaw NEPA as the general counsel of the Council on Environmental Quality for over 2 decades under Republican and Democratic administrations, testified before the committee that the principal cause of delay in implementing permitting are inadequate agency resources, project complexity, changes in budget, and other factors unrelated to permitting procedures or judicial review of environmental permitting decisions. To fix our nation's broken infrastructure, create jobs, and repair local communities, Congress should provide adequate funds for local projects, not to mention the agencies that approve these projects, rather than stack the deck in favor of potentially hazardous construction projects or real estate developments. So I oppose H.R. 5467, urge my colleagues to do the same. I ask, Mr. Chairman, unanimous consent to put into the record a statement from Professor Emily Hammond from the George Washington University Law School, as well as a letter to you and Ranking Member Nadler from the Alliance for Justice, who opposes this legislation. It says it undercuts the rule of law, weakens important statutory protections for public participation in federal actions, and drastically interferes with the very ability of the public to uphold those protections in federal court.
Without objection, they will be made a part of the record.
And lastly, Mr. Chairman, I'll end by noting the obvious, the absurdity of considering this bill today in the face of recent revelations about the reckless activities of the President of the United States at the White House, his ongoing efforts to undermine the rule of law, freedom of the press, and the ongoing and serious effort to undermine the investigation of the special counsel and this committee's complete failure to provide any oversight. And I ask unanimous consent to be put into the record this 55-page interim report by members of this committee, the Democrats, that detail our relentless efforts to call on this committee to do oversight that have been unanswered. Were unanswered again this morning when Mr. Nadler asked to go into executive session. And the absurdity of taking this bill up where there was no hearing and refusing to do our work is a disgrace. I'd ask this to be made part of the record. And further, I'd ask that a copy of this report be made and furnished to every single member of this committee so they can be made aware of exactly what we're not doing in terms of oversight. And with that, I yield back.
The document will be made a part of the record without objection. The rest of the gentleman's request is not in order. I now recognize myself for purposes of offering an amendment in the nature of substitute. The clerk will report the amendment.
Amendment to H.R. 5468 offered by Mr. Goodlatte. Strike all that follows after the
Without objection, the amendment will be considered as read, and I recognize myself to explain the amendment. At the Regulatory Reform Subcommittee's legislative hearing on H.R. 5468, testimony was offered to suggest that the bill could be improved by a clearer statement of which kinds of permits the bill covers. My manager's amendment acts on that suggestion. It makes clear that the bill covers those permits that are related to construction and the development of real property. These are the kinds of permits that were at the heart of the bill's inception as a means to assure that the benefits of Fast 41 would not go up in smoke were Fast 41 allowed to sunset, and they are the key kinds of permits for which broad permitting streamlining is needed to assure that critically needed investments in infrastructure and other construction and development can be made, bringing with them critically needed high-paying jobs. I urge my colleagues to support the manager's amendment. What purpose does the gentleman from New York seek recognition?
To strike the last word on the.
Gentleman's recognized for 5
Thank
minutes.
you. Mr. Chairman, this amendment makes a minor technical clarification, which is unobjectionable, but does nothing to improve the fundamental flaws of the underlying bill. I also must point out that with less than 10 legislative days before we recess for the midterms, our committee has taken no action to protect the Dreamers or to limit unconscionable family separations, no action to combat the scourge of gun violence and mass shootings plaguing our citizens, no action to investigate or respond to the wave of corruption sweeping through the Trump administration, no action to reform our nation's sentencing laws, no action to protect the Mueller investigation, no action to protect voting rights, and no action to reauthorize the Violence Against Women Act. And we ought to be taking up some of these issues rather than hastily passing, reporting this bill without proper hearings and an examination. I yield back.
Are there any amendments to the amendment?
Mr. Chairman,
Or does the gentleman from Maryland take recognition?
would the chairman yield just for some questions to explain the amendment?
Sure. You control the time. You ask the question, then yield to me, and I'll answer.
Okay, good. But I just, but of course, I do want to preface my remarks by aligning myself with the commentary of Congressman Cicilline and our ranking member that this seems like a wild and extravagant distraction from the business that has been at hand for 2 years that we haven't dealt with, including the DREAM Act, the legislation for a universal criminal and mental background check on gun purchases, which is supported by 97% of American people, which we haven't had a hearing on, the ongoing corruption and obstruction of justice we see in the Trump administration, the assault on voting rights that's taking place, the Violence Against Women Act, and so on. So I wish we were spending our time on this, but I do want to take seriously the legislation before us, and I did want to ask either Mr. Marino or Mr. Goodlatte, the chairman, some questions about the legislation just to try to figure it out. You know, in my other life, I've been a professor of law, and so I take the Administrative Procedure Act seriously. And so one general question, perhaps I would direct this to Mr. Marino, is do we really think that we should be amending the Administrative Procedure Act, which is a comprehensive roadmap for agencies to follow in conducting the regulatory process? Do we really think that we should be using the Administrative Procedure Act in order to pass a permitting statute? Why doesn't this justify hearings and its own statute as opposed to finger painting on the APA? And Mr. Marino, I don't know if you could perhaps answer why we've chosen this as the vehicle.
Because first of all, we had a hearing in the spring, and number two, because it is unelected bureaucrats making decisions that stifle the economy. When I invite you to come to my district, I invite you to talk to the small businesses, the medium-sized businesses, the people who want to build housing developments, the people who want to build factories that create jobs, and they'll tell you that 6-10 years is just outrageous. They put so much money into doing research, environmental research. I'm not an environmentalist, I'm a conservationist, and it just is not working out.
Okay,
And
well,
people
let me just
certainly
ask
have
you-
the right, these businesses who invest the money that they invest, have the right to have an answer, up or down.
Okay, well, let me reclaim my time. And Mr. Chairman, perhaps I can come to you. The terms permit and record of decision are inserted, I think, both in the bill and in your amendment, but they're nowhere defined in the APA. Do you think that we should define them if we are going to create a whole new legal apparatus around a, quote, record of decision or permit?
Well, if the gentleman would yield.
Please.
I'm happy to work with the gentleman if he thinks that adding definitions would be helpful, but they are very common terms, and I don't think that they will cause a problem for a court
Okay.
when they're readily available in other statutes and readily interpreted under the law.
Okay, but let me ask you about another ambiguity that I see in the amendment. The president can bypass an agency head to designate an official who can now set up a new timeline. Is there, the official is not identified. Could it be any official, no matter how high nor how low in the department? Does it even have to be in the department? And does the duty have to be delegated formally by the agency head?
Look, I think presumably the president would make a sound choice on who would handle that.
Okay. All right. I welcome your confidence. Let's see.
There are many such authorities delegated to presidents and other executive officials that do not explicitly spell out exactly how they carry that out. I don't think it's unusual in that regard.
Would the
Mr.
gentleman
Chairman-
yield? Would the gentleman yield?
Just 1 second. I want to pursue this for a second. The language of both the legislation and the amendment say that this official, unidentified official, could set a schedule for not later than 60 days of, I think the word there should be after rather than of, but anyway, 60 days of the filing of the completed application, okay? But that means it could be as short as 20 days or 5 days or 2 days. In other words, that official who's appointed by the president could set a process outside of the normal APA that is 48 hours, for example. I just want to make sure, is that the contemplation of the authors of the legislation? Because what we're talking about is the development of an ad hoc scheduling basis. There's nothing like that that I'm aware of.
What you're referring to is the amount of time that the individual has to set a schedule, not that that would be the schedule itself. So yes, if it's appropriate for him to set it within, to set a schedule that they will then operate under, but make that setting within 48 hours, a week, 2 weeks, he simply has to do it within 60 days.
Okay, but I'm reading it to say that they could schedule a process which is, it would take place within the next 48 hours. Is that not right?
I do not think that's correct.
Okay. The way I'm reading it is that an official could receive an application and set a schedule the next day that requires an environmental review to be done in 48 hours and then a final action to be taken in 3 days, which if not met would have to be deemed an undue delay by a court. So I'm glad that you're representing that's not the intention. It seems to me patently absurd that this would be our new administrative process. So
It is not.
okay. All right. Well, generally, let me just say, I understand maybe there's just a political point being made with the legislation, but it strikes me that it's just absolutely posting graffiti and finger painting all over the Administrative Procedure Act to put this in. If we want to do a separate bill about permitting, which is not even defined here,
The
then
root of the unnecessary delays that take place in the permitting process today is in the Administrative Procedures Act. Therefore, it is appropriate to amend that act to accomplish the goal of having more timely action on permit requests.
Okay, well, Mr. Chairman, I appreciate that perspective on it. The evidence that I've seen that comes from the Congressional Research Service and from the GAO suggests that permitting itself is not a problem, that the problem comes from funding and different kinds of public participation that are required. That's where the delays come from, and so, but we're blaming it on permitting, and then we're blaming the problem of permitting on the APA process, which has obviously been in place for decades. So I just wanted to express my opposition, and I yield back.
Mr. Chairman,
For purpose, the gentlewoman from Texas seek recognition.
to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. First of all, let me associate myself with the comments of my previous speaker, gentleman from Maryland. Having sat on this committee, I know that this is a journey that we've taken repeatedly under Republican rule, and that is to diminish the responsibilities of those seeking permits to comply with the best of what helps Americans be safe or the environment be safe. And that is in no way diminishing the importance of businesses proceeding with the work that may or may not contribute to the economy. But I rise to associate myself with the ranking member and his desire for an executive session on two of our colleagues. I'm not interested in talking and speaking of the details of my colleagues, but I am interested in the rule of law. And I am interested in a Congress and a committee that will unshackle itself from this tired response of the base that the President of the United States continues to coddle. We can't get anything done that is a responsible act on behalf of the American people. How can anyone, members of General Sessions' own party, cede to the dignity of America's lawyer being attacked for politicizing cases? I'm sure we all will have comments of what we like and dislike in indictments. But why we would not go into executive session to be able to determine whether or not the attack on General Sessions was in any way a violation of the Constitution, whether or not the President should be chastised or admonished, whether or not there should be full hearings, and whether or not the executive from the White House is tampering with the rule of law. Putting aside the Mueller investigation, I'm appalled. And I ask unanimous consent, Mr. Chairman, that my vote be placed in the record as an aye. Appropriately, I was detained in the Senate because of Judge Kavanaugh's confirmation. In addition, we have worked together, and I said in the Rules Committee yesterday, and I guess some people might have been taken aback, that we've worked in a bipartisan manner on this committee. And Mr. Chairman, you have attempted to do so. But we have had no discussions and hearings this year on sentencing reduction, which I've asked. I have a bill, the Juvenile Block Grant Reauthorization, Anti-Bullying and Prevention of Bullying, ready to go. I have spoken continuously on juvenile justice and the reform of such, and we have not been able to have it in this committee, nor have we been able to put it on the floor. But yet, with no disrespect to any one of my colleagues, we put a bill on the floor that was introduced last Friday, which tomorrow will make it 7 days, dealing with adding to the definitions of crimes of violence. Yes, it is meritorious to the extent that the Supreme Court asked for clarity, but there are no hearings, no experts, and the long litany of crimes that may, in fact, be nothing but entrapment for people of color. I note that one of the individuals that I have great respect for, Ms. McBath, her son Jordan Davis died at the hands of an individual who I believe shot him simply because he was an African-American boy. When are we going to address that question of violence? Why are we throwing on the floor of the House a bill that has not seen one light day of a hearing in this committee? Yet, we worked for 2 years on the Violence Against Women Act, which was introduced in the last week of July. We worked with the Republican staff. We worked with Republican members. We worked on issues that are confronting women today, and not one Republican, we asked one after another, would even cede that this was a need and that they would join us, similar to 2010, when 3 years this bill was held up. Why? They're not interested in Native American women being protected, one of the most abused population groups in the nation. They don't want to protect immigrant women, which is well known, who are in predicaments not of their own and suffer violence. They don't want to have a lockbox for perpetrators who have guns. But yet we can put a bill on the floor tomorrow with a long litany of untested comments that I guess people sat around the room and said, let me throw this on the ground. This is not the way this committee that has been called one of the most powerful or the most powerful committee in the Congress. And as someone who's served on this committee and loves this committee and the institution, and someone who we lost just a few days ago, who I felt was a great American, held in high esteem, Senator McCain said, we're better than this. And I think it's time for my colleagues to be better than this. Mr. Chairman, we have worked together. This leadership, we can be better than this. It does not make sense. And I'm not even going to talk about the midterm elections. I won't politicize my comments. I think we should work no matter what election is tomorrow, next week, or 5 years from now, because the American people expect for us, who have the Constitution in each one of our drawers, to be the kind of entity that they can expect justice rules and the rule of law rules. So I ask again, I did not hear you to place my vote as an aye for going into executive session. The motion moved by my ranking member, and I thank him for his leadership. And as well, my comments, hope will be responded to in some way. Women who are experiencing needing the Violence Against Women Act cannot wait. And I hope that they won't have to wait for long. Juveniles cannot wait for justice, and I hope they will not have to wait for long. I yield back.
The gentlewoman stated support for the gentleman from New York's motion is in the record by her own statement. We do not entertain unanimous consent requests to reopen votes at a later time under most circumstances. So we'll not do that, but your comments and your support of his position are duly noted in the record. What purpose the gentleman from California seek recognition?
I move to strike the last
Gentleman's
word.
recognized for 5 minutes.
I oppose this bill and this amendment. I also note that during the August recess, this committee held a closed-door hearing with FBI official Bruce Orr. During that hearing, Mr. Orr stated that Russian intelligence had Donald Trump over a barrel. I request this committee to immediately release the transcript of that testimony and to have an open hearing where Bruce Orr can come in and tell his story to the American people under oath. I yield back.
Are there any amendments to the amendment? What purpose the gentleman from Georgia seek recognition?
Move to strike the last
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. Back in January of 2017, there was a group of people who were excited about the prospects of positive change in this country. It wasn't the corporations, it was a lot of just regular people who I deeply respect. These are my brothers and sisters. We may disagree politically, but I know that they were looking for change. They were looking for a better life for themselves. It was we, the people. And so far, during this last almost 2 years now, it hasn't been about we, the people. It's been about we, the corporations. And people are real. Corporations are not, they are real too, but they're not real people. When will this committee get down to representing the goals and aspirations and values of the people? They are the ones who represent it, or those are the ones who elected us to represent them. But instead, what we get is a cascade of bills under the guise of so-called efficiency and fairness. But really what's happening is that we're doing the business on this committee of the corporations. Not one measure that has flowed through this committee since January of 2017 has had anything to do with making the lives of we, the people, better. It's been all about the corporations. This is flawed thinking. It's about trickle-down economics. You make the rich wealthy, and it'll trickle down to the regular people, the little people, as some have referred to my brothers and sisters as. So when we allow a green light to corporations to just pollute our environment without any stopgaps to help take care of the health and safety of the people who elected us, then we're working for not we the people, we're working for the corporations. when was the last time that this committee stood for more than just making it easier for corporations to make another dollar? Really don't care about the individuals who are out there, those working men and women struggling every day with escalating healthcare costs, with prescription drug prices going through the roof. They promised that they were going to work on that, but not one measure has done anything to help, and costs for health care have just skyrocketed, gone through the roof over the last 2 years. Who's watching? Who cares? Well, I know certain of us do, but the majority of us clearly do not.
Would the gentleman yield?
I will in just a second.
Yeah, thank you.
What is it that we have done when we talk about infrastructure, good jobs, increasing the wealth of working people out here? We've increased the income and net worth of the top 1% in this country with that tax cut, which is the only real, quote, accomplishment that this Congress can brag about. The folks on your side of the aisle, that's the only thing you all can brag about. Most people are mad about it. Not one thing about cleaning up Washington. In fact, when you talk about Washington, you talk about a cesspool that continues to deepen and expand, it's really something. And this committee has done nothing to stop it. It has put its head in the sand and has been willfully blind and professing innocent ignorance about it. But we know what's happening. The American people know it. And the American people are going to make some changes soon because they want us to work for them, not the corporations. And with that, I will yield to the gentleman.
Thank the gentleman for yielding, but I just noticed that there's 4 seconds to go, so I'll thank him, but get my own time here in a second.
All right.
Move to strike last word.
I'll yield back.
What purpose the gentleman from Ohio seek recognition?
Move to strike last word.
Gentleman recognized.
Thank you. I won't take the 5 minutes, but I just wanted to respond to one thing, or many things we could respond to that the gentleman said, but I'd just like to respond to one in particular. My friend from Georgia who said that healthcare costs have skyrocketed over the last 2 years and essentially blaming it on this side over here. I would just note that the Affordable Care Act, or Obamacare, whichever terminology one prefers, was passed when his party controlled the House and the Senate and the presidency, and we tried very hard quite a few times, and my colleagues on the other side of the aisle have mentioned that many times, how many times we tried to repeal Obamacare and replace it with something better.
Would the
We
gentleman yield?
tried, when I have 8 seconds to go, I'll yield, no, I'll yield prior to that.
Well, I'll take it.
I'll give you more than that. But we tried because many of us agreed that there were things in Obamacare or the Affordable Care Act, again, whichever one prefers the terminology there, that we agreed with. I agreed with keeping the requirement for pre-existing condition coverage. I like the fact that parents could have their college-age students up to 26 remain on their health care. There were some good things in it, which I would have voted for individually. But as a whole, I think what Obamacare did was screw up health care for everybody else without benefiting sufficient numbers of people. And that's why we thought we would do everything we could to replace it with something better. And we tried to, and we did it in the House. It wasn't easy, but we passed a plan which I thought was better. That's why I voted for it. And we almost got it through the Senate. So we almost got those health care costs down and replaced Obamacare with something better. But I would just remind my friend from Georgia that those skyrocketing prices that you're talking about in health care happened, I would argue, as a result of Obamacare, not because of any legislation that we passed, because we failed to replace it and with something better by one vote in the Senate. And I would be happy to yield the gentleman now.
Thank you. The gentleman is kind, and I appreciate that. When the Affordable Care Act was passed, insurance premiums were through the roof at double-digit levels every year. once the Affordable Care Act became effective, then the rise in cost of premiums declined into the single digits for years thereafter. And then we had January of 2017 come to us, and at that point, the promise to repeal and replace became an incessant task for the Republicans. You have the majority of the House, the majority of the Senate, and the presidency, but yet you were not able to repeal and replace legislatively.
Well,
you never really had a
reclaiming
replacement.
my time, and I know the gentleman is aware that the reason for that is not the House, because we did our job over here, and they almost did in the Senate. They failed by one vote over there, and there's the famous 60 votes that you generally need there. Now, as you know, we were dealing with reconciliation on health care at the time, just as we did with the tax cuts, because we could have never gotten 60 votes in the Senate for those things. But I would just, and again, I didn't want to get too far off in health care. I guess I did.
Well,
You
I'd have
I
just
took
one
the
more
bait.
point.
The gentleman yield.
I just
gentleman
have one
for
more
one
I'll
point
yield
to
very
make.
shortly to the gentleman, because I have one more thing I'd like to say. I yield.
All right. Okay, yes. With the inability to pass, repeal, and replace, then there has been an incessant movement towards sabotaging, and that is what has caused healthcare costs to
Reclaiming
rise.
my time, I differ with the gentleman on that, as I do with just about everything else the gentleman said. Nonetheless, I respect him. But I would just conclude with this, that none other than a former president and almost the spouse of another president said, and that's Bill Clinton, said very famously that, referring to Obamacare, that it's the craziest thing in the world that we're paying twice for health care what we used to pay, and we're getting half the coverage. That was Bill Clinton that said that, and he was right. They were able to quiet him down after that, because he was, I think, it was one of those gaffes in Washington where somebody speaks the truth and they have to shut it down very quickly, which was done. But I thank the gentleman for raising, it wasn't necessarily a judiciary issue, but it's probably worthwhile to get into it.
And if I could, sir, I
My
would
time's
say,
expired, but
I would say that the individual marketplace is one of those aspects of the Affordable Care Act that we needed to work on in a bipartisan way, and there just has not been the spirit other than to repeal on the other side of the aisle.
and
It's
replace.
unfortunate.
And replace.
It's unfortunate
which we
for
wanted
the
to do.
people that we represent.
And pre-existing conditions were in our plan too, despite the fact that lots of folks have ads being run out there right now saying that we voted to get rid of pre-existing condition coverage. It's absolutely not true.
Well, there was a
Yes,
lawsuit.
Obamacare had it in there, but we were repealing that and replacing it with something else that had pre-existing condition coverage in it, and I yield back.
But the lawsuit that is supported by my friends on the other side of the aisle seeks to do away with the ban on pre-existing conditions.
The time of the gentleman has expired. The question occurs.
Mr. Chairman,
For the purpose of the gentlewoman from Washington, seek recognition.
move to strike the last word.
Gentlewoman's recognized for 5 minutes.
Thank you, Mr. Chairman. I wanted to go back to our ranking member's motion to go into executive session before my comments on the bill and just say how important this is at a time when I think we are truly in crisis. We are seeing the most divided Supreme Court nomination happening in the other chamber. We have not addressed the issue of separated families. There are still 500 children who have been separated and not reunited with their families. And yesterday on CNN, Senator Graham tried to blame that on Jeff Sessions, which I thought was really interesting because the Trump administration has continued to do absolutely nothing to actually try to reunite these children. And we on the Judiciary Committee have still not had an open hearing, any kind of assessment of what has been happening there. We've just had 2 tweets from the president attacking Jeff Sessions for allowing the Justice Department to continue to investigate corruption. And, Mr. Chairman, I just wish that we would utilize the Judiciary Committee for what it should be utilized, which is to address the significant issues that are at stake right now in this country around election security, around Russians interfering in our election. Senator Graham also did, by the way, draw some red lines that I wish my colleagues on the other side here in the committee would draw, around not allowing for Robert Mueller to be fired, around not allowing for any kind of collusion, if that were to come to the forefront, to be accepted. I just don't think we've addressed any of those issues in a committee that has the authority, the scope, and indeed the responsibility to do so. I also wanted to say on this bill, I don't understand why we're debating this bill when we have so many things in front of us, but I am in opposition to this bill, which I see as another bill that is in search of a problem. It's a poorly disguised attempt to dismantle well-established procedural systems in the interest of advancing a corrupt system that sacrifices important environmental protections and maintains healthy competition among businesses. 5468 would severely limit judicial review of federal permitting of construction and real estate projects while making it more difficult to actually block the approval of those projects when they endanger the public or the environment. It drastically shortens the period of time for the public to file a claim from 6 years to 6 months. 6 months to file a claim, and that is a 92% reduction in time. It's an outrageous handout to corporations. And in particular, the bill undermines judicial review under NEPA, the National Environmental Policy Act, which was landmark legislation introduced by Washington State Senator, my state, Henry M. Jackson, in his words, to prevent or eliminate damage to the environment and the biosphere and stimulate the health and welfare of everyone. The bill requires careful consideration of the environmental effects of federal actions, and in cases where a proposed action presents those significant environmental consequences, agencies have to take into account an action's environmental, socioeconomic, and cumulative effect and impact. It's the smart thing to do and absolutely necessary for the health and well-being of all Americans. But instead, this bill requires courts to consider the environmental benefits, but not the harms of a permitted activity, in addition to the economic and environmental costs of any delay in undertaking the activity. That's preposterous. Supporters of this bill might as well just come out and tell the courts not to consider any harm to the environment whatsoever in reviewing these permits. Many of my colleagues on both sides of the aisle were back home on the West Coast very recently, and I know many of you saw and experienced the devastating wildfires that are increasingly ravaging our states at unprecedented levels. These events are the latest in a long line of evidence, however much others on the other side might like to deny it, that climate change is indisputably real. And if you experience the unrelenting haze of smoke that many of our homes, my home in Seattle, were suffocated in for weeks, you would know, like I do, that it's not the time to undermine crucial environmental regulations. Further, the bill authorizes judges to impose a $5 million bond on litigants and makes it nearly impossible to regain those funds. So essentially, this places a $5 million fee on the ability to challenge a federal permit in court, which is unconscionable, and it puts public engagement out of reach, not just for the little guy, by the way, but for small businesses, for non-governmental organizations, and state and local governments. And in the case of small businesses, this brings up serious concerns about competition and the impact on consumers. So if we're serious about improving the federal permitting process, we should look at what we're doing to properly fund and support the NEPA process across all federal agencies, like supporting interagency involvement, especially with state and local partners, and encouraging civic engagement amongst our constituents. So I strongly urge my colleagues to oppose this bill, and I believe that the health of our people and our environment depends on that. Thank you, Mr. Chairman. I yield back.
Time of the gentleman has expired. For purposes of the gentleman from Texas, seek recognition.
Strike last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. And I have been greatly encouraged to hear friends across the aisle talk about the need to rein in corporations. And of course, they're mistaken in saying we're not for doing that on this side of the aisle. I am thrilled to have Democrats who will help us go after the biggest corporations who are now squelching free speech, First and Second Amendment rights. We do need to go after them, and I'm glad it's going to be a bipartisan effort, because when we had some of the biggest corporations in the country, for example, whether it's Google, YouTube, Twitter, Facebook, which is discriminating through algorithms against free speech, involved in what sounds like fraud, getting people to pay them big bucks to send their messages to the front when they're actually going to the rear. I think it's great we're going to have bipartisan support in going after them. I think it can be corrected by just doing what was suggested, and that is having liability the way newspapers or other publishers do. I think that'll be very helpful. So I'll appreciate getting Democrat votes so that people can sue Google and YouTube and Facebook and Twitter for the abuses and fraud and the outright intentional taking of free speech rights. Now, with regard, I was just recently in California, where a family member lives, and I'm very sensitive to the wildfires. I am so glad that came up, because that makes this bill more timely than just about anything we could do. Talking to a good friend, congressman from Montana, about why are there no fire breaks being cut through these forests, so when the fires start, for heaven's sake, we can stop them. And firemen aren't just putting their lives, foregoing their lives to try to get in there and stop them. Why are we not taking out underbrush that feeds these fires? We've even heard testimony at a previous hearing, different committee, about how refusing, being unable to clear the undergrowth of these forests is keeping wildlife from being able to get into their habitat and get food, then starving them. And it's all in the name of NEPA and preserving the environment. When we see the smoke, we see the hundreds of thousands of acres being burned up. For what? So that people can cost millions of dollars and hold up any efforts to tend the garden, as the Bible talked about the job of Adam and Eve. We have a job of tending the garden, and the courts have been used to stop the efforts to prevent fires. We can't do anything about lightning starting a fire, but we can sure do something to tend the forest, tend the gardens, build fire breaks, cut through there so when a fire starts, we can stop it. But the courts have held these things up over and over. Hundreds, thousands, who knows how many homes have been destroyed because people have run to the courts. In prior years, we've had hearings in Washington State, other places, and heard about how it costs millions of dollars to create a ladder so that they could be sure, after a power plant was there, that the salmon could get up to their spawning place. And then we find out the ladder actually allowed sea lions to get up into an area they never could have gotten to, and just had a big smorgasbord on the salmon. The courts have created a problem for us protecting people, protecting the land, protecting the wildlife, and I think this is a great bill. Could not be more timely to protect those homes and lands and forests. And so I applaud the bringing of this timely bill to try to save lives, to try to save homes and forests and wildlife. And I hope people will join across the aisle.
Would the gentleman
trying
yield?
to stop that.
Would the
I'm
gentleman
yielding
yield?
back my time. I'm done.
Mr. Chairman?
Wait.
Mr. Chairman?
I really appreciate this debate that's going on and on and on, but most of it has very little to do with the subject at hand. So the woman from California, for what purpose does she seek
To
recognition?
strike the last word, and I'll be brief.
The woman is recognized for 5 minutes.
I just, as the chair of the California Democratic Delegation, a state that has suffered greatly from fires, which everyone acknowledges has been aggravated by climate change conditions. I just wanted to note that, and I won't go point by point, but the statements made by our colleague from Texas are quite incorrect and misapplied in terms of how the fires spread, the state of litigation in the state. I just can't allow those misstatements to go unrefuted, but I will not take the time of the committee to go through point by point. It's concerning, given the suffering that so many of my fellow Californians have experienced, that would be brought. I'm sure the gentleman's intentions are fine, but the statements are simply incorrect. And I see
Would the
Mr.
gentleman-
Sis,
would-
I'd
would
be
the
happy to
gentlewoman-
yield to the
Thank you.
gentleman from Georgia.
With respect, my dear friend, to the algorithms that are in use today, they are ubiquitous. It's really artificial intelligence aimed at predicting human behavior. And these algorithms determine whether or not people get credit, and if so, what is the interest rate. It determines how much you pay for insurance. It determines whether or not you can rent an apartment. It's in the criminal justice system. It determines whether or not folks can get jobs or not. And that whole algorithm industry, the predictive behavior patterns, are set by people who are anonymous, they are private, they're doing it for a profit, and it actually operates to bake in a permanent inequality for certain people in our system. And so I think the issue of artificial intelligence and its impact on human behavior in America is an issue that is beyond ripe for this committee to take up. Those are the kinds of things that I would like to see this committee working on, among other things. And with that, I'll yield back to the gentleman.
Reclaiming my time, I would just like to note that there's been a lot of misinformation in this committee and talk that is, I think, seriously misunderstands the nature of algorithms and search. The gentleman's comments about the potential for inadvertent discrimination is important. And it's one that I think the Science Committee actually ought to look at so that we can examine the potential, the algorithms, because the algorithms are now being devised not by humans, but by artificial intelligence, and always are worth examining for. But there are, how many links, the page link is something that really refers to Larry Page, not just numbers of pages, and how search is conducted and the various factors so you get a good result is really not related to any kind of politics. We're lucky that we have Mr. Liu here, who's a computer scientist before he was a lawyer, who could probably explain this much better than I. But
Well, would the gentlelady yield?
I'd be happy to yield.
I would respond that the data that goes into the analysis, which forms the algorithms, is put in by people and is subject to personal bias. And so
And reclaim my time, I acknowledge that there is the potential for risk and it deserves examination, and I think the proper examination point would be the Science Committee to take a look at the science behind it and so that we don't rush off into assumptions that end up being incorrect, even though there may in fact be a legitimate issue to review. And with that, Mr. Chairman, I yield back.
Mr. Chairman,
What purpose the gentleman from Rhode Island to take
I
recognition?
move to strike the last
I
word.
was recognized for 5 minutes.
I just want to respond briefly to my good friend from Ohio's comments about the state of healthcare in this country, because I do think we have to be careful to kind of make assertions because facts do matter. There are a variety of ideas that have been presented by my colleagues on this side of the aisle to improve and build upon the success of the Affordable Care Act, to increase competition, to enact payment reforms, to make real investments in wellness and prevention. The Republican response, and all of this is predicated on expanding access to health care, driving down the cost of health care and making it more affordable for the American people. The Republican response has been quite different. The Trump care that they refer to as their replacement would have resulted in 28 million Americans losing their health insurance. The tax bill, or the tax scam that my colleagues passed, that will result in 13 million Americans losing their health insurance. And because they got rid of the individual mandate, it will drive up premiums for the rest of us. Because when you take the healthy people out of the insurance pool and you leave the older, sicker people, you drive up costs for everyone. The administration has also sabotaged the implementation of the Affordable Care Act by cutting funding by 90% for the open enrollment period. So the money needed to encourage people to sign up for insurance. They cut the period for enrollment period significantly. They prevented a payment of healthcare subsidies. They've allowed the sale of junk plans. So this notion of like, oh, how is this happening? These are decisions made by the Republicans in Congress and this administration that are resulting in higher healthcare costs for the American people. We have ideas on how to drive those costs down, but this notion of like, oh, if only we didn't have the Affordable Care Act insurance, just not true. And so I just think it's important when the suggestion or the implication is made that this is the result of the passage of the Affordable Care Act that resulted in millions and millions of Americans having insurance for the first time. And the irony that in the very moment that these claims are made, the Republicans are in court in a lawsuit to try to take away coverage for pre-existing conditions. They couldn't do it legislatively, so now they're trying to do it in the courts because they don't believe in it. And so it's sort of mind-boggling. But I have one bit of good news. There's something this committee can do about it. We have a bipartisan bill, Mr. Marino and I, the CREATES Act, that will help make it easier to get generic drugs into the marketplace. The CBO scores that it will save $4 billion to consumers and taxpayers because it will drive down the cost of prescription drugs, a serious issue for my constituents, for people all over this country. So I hope that the chairman, or maybe my friend from Ohio, will use his influence with the chairman to bring the CREATES Act before this committee to mark it up and do something to drive down healthcare costs. And with that, I yield the balance of my time to Mr. Raskin.
Thank you very much. Thank you for yielding. And I associate myself very strongly with the remarks of Mr. Cicilline. One way to destroy people's health care is just to throw them off their health care, as it was proposed to do with more than 20 million Americans. Another way to do it, of course, is to go to court to try to sue to destroy pre-existing condition coverage, which our Republican friends have done now as they attempt to destroy pre-existing condition coverage and insurance across the country. But another way to do it is to undermine environmental protection, and that's precisely what this legislation is about. If you think about it, they want to make us more like China. In China, the government can easily displace people and build roads and highways and industrial complexes wherever they want without consideration for the environment, without consideration for the public health or public participation, without consideration for protection of endangered species. This bill is an attempt to perform an end run around NEPA, the National Environmental Protection Act, by desecrating the Administrative Procedure Act. And actually, China has begun to recognize the terrible social and environmental costs of its pollution policies, which have turned the air dark gray and black throughout the country. And now they want to move us in the other direction to dismantle our environmental regulation by taking away the rights of people in court to enforce their environmental rights, and by allowing courts to impose a $5 million bond on people suing to vindicate their rights. This bill, which appears out of nowhere at the last minute of this hopeless legislative session which the Republicans have run, is nothing but an attempt to give away the rights of the people to the biggest polluters and corporations in the country. And we know that President Trump is himself a builder who's declared himself the #1 champion of eminent domain in America, which is the process by which people's property rights have been trampled and the environment has been ruined in many parts of the country. And this is a very fitting way for them to end this terrible session. I yield back.
The time of the gentleman has expired. The chair would note that this is not something that's appeared out of nowhere. We held a hearing on it 5 months ago. So this issue is timely. The question is on the amendment in the nature of a substitute to H.R. 5468. Those in favor will respond by saying aye. Aye. Those opposed, no. In the chair, the ayes have it, and the amendment is agreed to. Reporting quorum being present, the question is on the motion to report the bill H.R. 5468 as amended favorably to the House. Those in favor respond by saying aye. Aye. Those opposed, no.
No.
The ayes have it, and the bill is ordered reported favorably. For purpose of the gentleman from New York, seek
Yes,
recognition.
the ayes and nays.
Yeas and nays have been requested, and the clerk will call the roll.
Mr. Goodlatte?
Aye.
Mr. Goodlatte votes aye. Mr. Sensenbrenner? Mr. Smith? Mr. Shabbat? Mr. Shabbat votes aye. Mr. Issa? Mr. King? Mr. King votes aye. Mr. Gomert? Mr. Gomert votes yea. Mr. Jordan? Mr. Poe? Mr. Marino? Mr. Marino votes yes. Mr. Gowdy? Mr. Labrador? Mr. Labrador votes yes. Mr. Collins? Mr. Collins votes yes. Mr. DeSantis? Mr. Buck? Mr. Ratcliffe? Ms. Roby? Ms. Roby votes yes. Mr. Gates? Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes aye. Mr. Rutherford? Mr. Rutherford votes yes. Ms. Handel? Ms. Handel votes yes. Mr. Rothfuss? Mr. Rothfuss votes yes. Mr. Nadler? Mr. Nadler votes no. Ms. Lofgren? Ms. Lofgren votes no. Ms. Jackson Lee?
No.
Ms. Jackson Lee votes no. Mr. Cohen? Mr. Cohen votes no. Mr. Johnson of Georgia? Mr. Johnson votes no. Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu? Mr. Liu votes no. Mr. Raskin? Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Mr. Schneider? Mr. Schneider votes no. Ms. Demmings? Ms. Demmings votes no.
Has every member voted who wishes to vote? The clerk will report. Gentleman from California.
Mr. Issa votes yes.
Clerk will report.
Mr. Chairman, 13 members voted aye, 11 members voted no.
The ayes have it, and the bill is ordered reported favorably to the House. Members will have 2 days to submit views, and without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. This concludes our business today. Thanks to all the members for attending. The markup is adjourned.